One of the elements to make a contract intention to create a legal relation means the intention of a party to become legally bound with a legal consensus to sue or to be sued. An agreement must have legal effect. The Contract Act is silent on whether the intention to create a legal relation is one of the requirements to form a valid contract. Existence of an intention sometimes cannot be seen directly. By that, in order to determine whether the intention to create a legal relation exists, the law classifies into two parts: presumption of legal intention and presumption of non-legal intention.
Good morning, Dr. Kuzaima. I'm Tan Wei Ling. I would like to present about the principles for vague and uncertain terms in the topic of intention to create a legal relations. Firstly, if a term used was vague and uncertain, then there is no contract as there was no consensus ad idem. What is consensus ad idem? Consensus ad idem means that agreement or a meeting of the minds of all involved parties in a particular contract and is consented mutually. If no consensus, thus no common intention to create legal relation, thus a contract will not exist. Let's look at one of the case. In the case of Pyong Hon against Cho Chai Fa, the appellant alleged that his stepson, the respondent, had transferred a piece of land to him. However, the respondent denied. Therefore, the federal court held that appellant have bore the burden to prove the respondent intention to transfer, but appellant have failed to do so. Besides that, the federal court said that the term in the document was so vague, so unclear and uncertain. Thus, no intention on the part of respondent existed. Hence, this case shows that the transfer of land from stepson to stepfather was not valid at all. In conclusion, principles of vague and uncertain terms will not contribute to a legally binding contract as there is no intention to create a legal relations. And that's all from me. Thank you very much.
It is not possible to use a name or a label to indicate that no intention existed. The law, not the label, determines the relationship between the parties. Example case law could be Malayan Banking Berhad versus against Fikir Rajamani, where the judge held the right approach would be to look at the substance, not just the label which had been attached to the record. The law will always look beyond the terminology of the documents to the actual facts of the situation, and it is no longer a question.
Hi Miss, when's the contract that I need to sign for the house that I buy? And plus, I already transferred $700 yesterday. Have you received? Oh yes, I already received the $700 and this is the contract that you need to sign to be bound with the contract. Okay, you sign first. Okay, that's mean that our contract already concluded and I already received your money. Okay. Thank you. Alright, bye. Hi Miss Matthew. I would like to inform that the price for the house is already increased. What? No way! I've already paid $700. You cannot cancel like that or raise the amount, and I am not going to pay for the additional payment. You don't want to pay? Or if that's so, I would like to ask for the court for specific performance. The appellant, which is Diamond Development Senjam Berhad, argued that the form was subject to contract and no contract existed until both parties agreed and signed another document. The court ruled that the form didn't make the purchase or signing conditional on another agreement. The appellant was bound by the form, and despite their argument, the form did create contractual obligations.
Presumption of the courts consists of two, which presumption that have legal intention and presumption that have no intention. The first one that we are going to explain is presumption of legal relation, or being called as commercial agreements. The scene that has been shown just now is one of the examples for commercial agreement. Both parties intend to make a legally binding contract. Any agreement executed or made in the ordinary course of business between two business is intended to have the intention to create legal relation.
In married case, they are husband and wife fall into love and married together in 1941. They held the matrimonial home with joint names. However, after some time, they started to quarrel.
I cannot prolong you anymore.
So let's get divorced.
In 1966, Mr. Merritt left the family home to live with another woman.
I want the matrimonial home back. I will pay for the balance.
Sure, alright, I agree on that.
Upon Mrs. Merritt's request, Mr. Merritt signed a document confirming that when she had repaid the balance on the mortgage, he would transfer the matrimonial home into her sole name.
I have finally paid for the mortgage. The house belongs to me.
He shouted and unsatisfied. Mrs. Merritt paid off the mortgage and successfully acquired a declaration that the house belonged to her. Mr. Merritt appealed. The case Balfour. The husband and wife were happily married. One day, Mrs. Balfour got an offer letter to work in overseas.
Let's go to Ceylon together.
In 1915, both of them went to England for a vacation during Mr. Balfour's leave. When it was time to return back to Ceylon, Mrs. Balfour was advised not to return because of her health, and Mrs. Balfour had suffered rheumatic arthritis and need to remain behind in England for medical treatment. One day, the doctor said, "Mrs. Balfour, you are advised to stay back here in England due to your health issue."
Yeah. Since you can went back with me to England, I promise you to pay $30 per month until you can went back with me. So, take care.
Mrs. Balfour brought this action for the money her husband had promised to pay to her, but he failed to do so. Court decided that the agreement between husband and wife cannot be enforced legally as the said agreement did not have an intention to be legally bound. Both parties have no intention to create a legal relation as the husband and wife is living in amity and there is no indication that there will be separation between husband and wife. Thus, there are no intention between them.
I'm on the case.
Social arrangement does not amount to contracts because the parties do not intend to create a legal relation. To illustrate, couples living friends do not amount to contract even though they contributed to the payment of the contract.
Hi guys, today we are going to discuss a case in the topic of social arrangement. And this is the landmark case for social arrangement, which is a case between Mr. Coward and Motor Insurance Bureau. Okay, let's hear about it. One day, Mr. Coward rode motorcycle with Mr. Cole. They were in a very bad luck when they had accident and both of them were killed. Mrs. Coward declared that Mr. Coward paid a weekly sum for the ride to Mr. Cole. Mrs. Coward arose issue if Mr. Coward was carried for hire or reward. The court ruled he was not, as neither he nor Mr. Cole intended to enter into a legal contract for the transportation service. And that's the end of the case. So there is no contract between Mr. Coward and Mr. Cole.
There are some ways for rebutting contract. First, advertisement. There is no presumption on advertisement because it is a statement which just a mere puff attracts someone to buy and thus no intention to create the binding contract. Second is honor clause. Honor clauses is where we expressly declare not binding. Thus, the commercial contract will not bind the parties. There is one case regarding honor clauses where the held of court stating that the agreement wasn't legally binding when there is honor clauses. Third, Memorandum of Understanding, which is MOU. MOU only connotes memorandum witnessing the mutual understanding between the parties. It is a preparatory agreement for a preliminary agreement, not valid and enforceable as a contract. Not all MOU can legally binding.
The manifesto do not bound to fulfill it. No intention to create legal relation as it is not an agreement commercially. For example, the manifesto that has been declared by the future leader, and if the manifesto is not being processed, we cannot demand it as saying it is a binding contract. In fact, manifesto is not legally binding. A letter of intent is a document outlining the understanding between two or more parties which they intend to formalize in a legally binding agreement. They just interested to make a contract, not to intend it to make a contract. Pro forma. A clause is added to a commercial agreement to eliminate the liability or to rebut the original presumption. Thus, it is not a contract even though the parties are in the process of negotiation and hope to have a formal contract later on. The effect of this clause is that the oral or informal agreement is not binding until the execution of a final agreement.